Welcome back. Just before the break, we were talking about many situations when people, green card holders and citizens, get married and want to apply for the husband or the wife for the green card. Now, I am going to talk about people that come here on a temporary visa. Let us say B1, B2 visitor visa. The boy is a citizen here and the girl just came in. After coming in about 2 or 3 weeks, they get married and they file the papers with immigration, which is legal. She entered legally and she is wife of a US citizen, nothing wrong with it. Do you know what is wrong with it? Issue of preconceived intent. She used the visitor visa to come to US, which is only for the purpose of visiting and going back. But actually it is very clear that she had already a preconceived intent. पहले से ही उसको पता था कि मैं जा रही हूँ अमेरिका में, जाते ही शादी करके ग्रीन कार्ड के लिए अप्लाई करूँगी. So she misused, she lied in a way. But nobody asked me any question at the airport. They don't ask the question. The type of visa on which you are entering is implied, is understood that you are coming only to visit. So if a person like that has applied, with a few cases we saw, after 2 weeks they applied for the I-130 and the 485. And the immigration officer at the time of interview said, well, did you not know that you were coming to get married? No, no, no. So what, 1 week you met him on the street? How did you meet? We met in a party. You met him at a party and told him, okay, let's get married tomorrow. It's not believable. It's not believable. There we have actually an official 30, 60, 90-day rule. Anything happens in the 30 days, it is considered preconceived intent. 60 days maybe. 90 days or more, little bit of problem. After 90 days, generally it is okay. So one has to be very, very careful, because the preconceived intent may go into again 6C, that is the lifetime bar and the big problems again. And it is sometimes very difficult to get even a waiver if it is a married couple, they have not lived together long time, there is no children born out of the marriage. So this is something really to consider, because we see those cases also. They just come and get married without understanding the preconceived issue. But this may not happen in some other cases. Person is here on H-1B visa, for example. Person is on maybe an F-1 student visa, for example. Or a person came on a visitor visa 4 or 5 months ago, now then gets married. Those cases understood that there was no preconceived intent, and those cases generally go very smoothly. Now, the other issue, the questions we get from people is people waiting long periods of time in employment categories because the visa numbers are not available. For example, the EB3 category is right now January 2003. That means those who applied before January 2003 are now getting in 2013. Already 10 years of waiting, and God knows how long more. The EB2 category, some good news is there, as I told in the last time, in that has moved to 2008, but it's still about 5-6 years waiting period. So what shall they do? They are saying, what shall we do? Is there any other options? Yes, explore other options. Now, one of the options people probably know or don't know is the rule of cross chargeability. If you are a citizen of India, you come under the Indian quota. But if your wife or husband was born in a different country, Pakistan, Bangladesh, Kuwait, or many of those countries, you can take the number of the wife's quota from that. So that for example, EB2 is the current. So if your wife is born in Bangladesh, Pakistan, Nepal, any place, you can immediately notify immigration and your case will be put in that category. And the same thing about the EB3 also, same thing. EB2 also, same thing. So this is something to be considered, to be taken into consideration. People might have got married a girl who was born in Indonesia, any country, don't realize that this has a big impact or effect on my case. There is also another, if something is not, both are born in India, so there is no rule of cross chargeability. So then the issue is that the EB3 guy who is already waiting 10 years, many more years to still wait more, can explore the option of filing again, maybe through same employer or other employer, an EB2 case, which is much better because they are already at 2008 now. So that may be 5-6 years against the 10 or 12 years. So that's one option to look into that case. The person may be single. He has applied for a green card under employment of sponsorship, but he is single. How about getting married? getting married to a citizen, getting married to a green card, you get your green card right away. But some people think, oh, but I have already applied in one category, does not matter. You can have 2 petitions, 3 petitions, 4 petitions, stay in different lines. So, these are some of the suggestions that we can give it to you. And once in a while we always get a case where a person applied and he is waiting, visa number came also gone away, he is not taken action, he has not responded to NVC, he did not go for interview or something. After a year or two, that case will be closed and be sent back to the National Visa Center and shredded there. Chop off kar dete hain, wo khatam ho gaya, there is no record with immigration anymore. So, what is the suggestion? Be careful, watch out cut-off dates every month, watch out where you are, and then continue to follow. Once you follow with the immigration or the NVC, that will continue, they will not chop off the case. Now, the other question that we get all the time, especially from elderly people who got a green card, son or daughter applied for them, they have a green card, they do not live actually in US, they come back and forth every year. So, green card is not a driving license. Basically, you got an immigrant visa, my friend. Immigrant visa is given by the government of the United States to come to the US and settle down, live here and work here, and not visit and go back, visit and go back. So, what is the suggestion? First of all, I think do not remain outside of US for more than 6 months at any time. That is a big thing. If you are traveling back and forth, if you buy a ticket from US round trip, that means you are going to India and coming back, rather than buying a ticket in India to go to US and come back, because why is that so? Person is living here is supposed to be going and coming back. So, that is one thing, they always look at that, and then it becomes a hassle all the time. Every time the parent comes after 8 months, 6 months, they want to ask questions and they raise issues. So, it is a good idea to have all kind of other documents. Person has an income, he should file tax returns, he has a driving license, he has bank accounts, he has credit cards, many kinds of evidences, driving license. If a person gets into trouble or the government is asking or they put in even exclusion proceedings, those kind of documents will help him a lot to keep the green card alive. The best thing is, if the parent does not want really to settle in the US, he can surrender his green card, apply for visitor visa 10 years, not a problem at all, and be done with it. So, hopefully, all that information today provided to you will be very helpful to you. If you have any questions, please feel free to send us an email. We will be more than happy to respond to you. Put that email through my attention. Well, thank you very much for watching the program. Please keep watching us every Saturday at 1 p.m. only on TV Asia. Thank you.